Now I am going to dictate a legal passage at the rate of 100 words per minute based on latest Supreme Court judgment. Let's start. At the outset, it appears pertinent to reiterate the settled position that the doctrine of lease pendants as provided under Section 52 of the Act does not render all transfers parental to be void ab initio. It merely renders rights arising from such transfers as subservient to the rights of the parties to the pending litigation and subject to any direction that the court may pass thereunder. Stop para. Therefore, the mere fact that the RSD was executed during the pendency of the underlying suit does not automatically render it null and void on this ground alone. We find the impugned order to the wholly erroneous as it employs Section 52 of the Act to nullify the RSD and on that basis concludes that the implement application is untenable. Stop para. Contrary to this approach of the High Court, the law on implement of subsequent transfers as established by this court has evolved in a manner that liberally enables subsequent transferees to protect their interests in recognition of the possibility that the transferor parental may not defend the title or may collude with the plaintiff therein. See the decision of this court in Amit Kumar Shah versus Farida Khatun within bracket 2005-11 SCC 403 and A. Nawab John versus V.N. Subramaniam within bracket 2012 7 SCC 738 para. Similarly, we also find fault with the order of the ADJ and its misplaced reliance on Bibi Jubeda within bracket Supra. The only principle emerging from the judgment of this court in Bibi Jubeda within bracket Supra is that transferees parental cannot seek implement as a matter of right, and to that extent we agree with the ADJ. However, Bibi Jubeda within bracket Supra does not place a bar on implement of transferees who purchase property without seeking leave of the court. Stop para. The decision of the court in Bibi Jubeda within bracket Supra turns on its own facts. The court rejected the application for joinder therein. Nothing that the underlying suit was pending since 1983 and upheld the finding of the trial court that the subsequent purchaser was not bona fide and attempted to complicate and delay the underlying suit. Therefore, the judgment in Bibi Jubeda within bracket Supra being distinguishable on facts does not assist the respondents herein. Stop para. The respondents herein assail the implement of the appellant on the ground that he is not a bona fide purchaser as he had full knowledge of the pending litigation. While that is the admitted position, there exists no bar to the implement of transferees parental with notice permitting the implement of a transferee parental is in each case a discretionary exercise undertaken to enable a purchaser with a legally enforceable right to protect their interest, especially when the transferor fails to defend the suit or where there is a possibility of collusion. Para. In the purchaser facts and circumstances of this case, Mr. Sundaram has been able to satisfy this court on the possibility of conclusion between the respondents. It is a fact that the plaintiffs and defendants are relatives. More importantly, plaintiffs approached the court in the underlying suit after a substantial delay of 11 years, whereas admittedly the revenue records were mutated to reflect the name of respondent number 21 since 2007. It is also curious that the claim of non-payment of consideration by the appellant was made for the first time before this court para. On the other hand, the appellant has a registered sale deed in his favor and has therefore seemingly acquired an interest in the subject land. Whether or not the consideration was paid is a disputed question of fact that shall be determined by the trial court. Stop. Thank you.